Across 3 decades of records, U.S. authorities repeatedly approached the Rainbow family as a possible conduit for serious threats, ranging from subversive violence and missing child cult activity to national security risks and organized drug trafficking. Yet each investigative wave collapsed once checked against evidence, yielding little more than individual criminal cases and unverified rumors. By the late 1990s and early 2000s, the gatherings had become routine special event monitoring exercises, with agencies preparing for drugs, fugitives, and crowd control issues, but internally acknowledging no substantiated link to terrorism or coordinated criminal conspiracies. The overarching story is one of recurring suspicion that never crystallizes into the major threat federal agencies repeatedly anticipated. 1975, First FBI Look. Subversive Matter and Scary Rumors. The story of the FBI's 1975 investigation into the Rainbow family unfolds like a quiet mystery set in the American interior, beginning with a whisper in Arkansas. In the spring heat of that year, a narcotics investigator from the Arkansas State Police hears the same unsettling rumor twice. A large, wandering collective called the Rainbow family is supposedly heading toward the Ozarks for a July 4th gathering, and somewhere within its drifting ranks may be a leader wanted for killing a police officer in Utah or Colorado. The investigator, unsure whether he is dealing with a harmless counterculture caravan or a dangerous fugitive network, passes the information to the FBI's Little Rock office. On May 16, the Bureau fires off an airtel to Denver, echoing the rumor in the clipped tones of official correspondence. Thousands of people, buses, hitchhikers, folk festivals, rumors of homicide, and the possibility of an organized threat moving across state lines. Within days, the rumor begins to tangle. Another Arkansas source claims that a sizable portion of the Rainbow family is planning to gather at a ranch north of Bryan, Texas in late June, to appear on television and make a recording, a detail so odd and specific that agents cannot quite decide whether it increases the credibility of the story or undermines it. More troubling is a separate tip alleging that the Rainbow family is involved not only in narcotics distribution but in activities aimed at overthrowing the United States government. Little Rock, now treating the matter as a possible subversive case, widens the investigation. On May 30th, it circulates the allegations to a constellation of FBI offices across the West and Southwest: Dallas, Denver, Los Angeles, Phoenix, Portland, Sacramento, Salt Lake City, San Antonio, San Francisco, Springfield, asking each office to scour its indices for any trace of the group, its supposed leader, or signs that the murder rumor has substance. Denver and Salt Lake City receive explicit instructions to determine whether any outstanding warrants exist for a Rainbow figure wanted in connection with the killing of a police officer. The Bureau's internal machinery begins to hum. Meanwhile, on the ground in Arkansas, investigators encounter something more concrete than rumors. In the small town of Marshall, Searcy County, they find pamphlets scattered around town bearing the title Rainbow Gathering of All People. The pages invite all tribes and people everywhere to come to the Arkansas hills from July 1st to 4 for days of meditation, prayer, singing, and dancing, culminating in a moment of silence at noon on Independence Day. A local phone number and a Little Rock post office box appear at the bottom. When agents trace both, they find not a clandestine revolutionary network but a crisis hotline called Helpline, which assists runaways and provides information about drugs, pregnancy, and abortion. The discovery complicates the picture. The infrastructure behind the gathering appears rooted in local social services rather than in an underground organization. At the same time, the Searcy County Sheriff receives word that hundreds, perhaps as many as 1,000, Rainbow family members are indeed planning to enter the Snowball area in early July. Acting on this, investigators travel into the hills and note a blue Ford Mustang with Arizona plates parked near the expected gathering site. Documents inside the vehicle identify its owner and provide personal details, though these are later redacted from the Bureau's files. From another long-standing source, investigators compile a short list of individuals believed to be Rainbow family members, and this list becomes the basis for the next phase of the inquiry. Names, addresses, and fragments of information are sent out across the FBI's field offices like pieces of a puzzle scattered on a table. Salt Lake City takes the assignment seriously. Agents dig through their indices for records of the Rainbow family, for hints of drug conspiracies, for any individual tied to a police killing. They find nothing. No organization by that name. No leader on the run. No warrant matching the rumor that started the entire investigation. A driver's license check on one of the individuals produces a valid Utah license, but it turns out to be registered to someone else, The license photograph and physical description are forwarded to Little Rock nonetheless, more out of procedural duty than investigative promise. On June 5, Salt Lake City formally reports negative results. On June 17, it sends the follow-up, the copied license, the descriptive details, and a clear statement that nothing more remains for the division to pursue. As June turns to July, the Bureau finds itself holding little more than a handful of pamphlets, a set of redacted names, a blue Mustang, unverified rumors about narcotics and subversive activity, and a central allegation, the fugitive leader wanted for killing a police officer, that no field office has been able to corroborate. The dramatic threads that animated the early reports begin to unravel. No warrants emerge. No evidence of a conspiracy surfaces. The Rainbow family, in the Bureau's files, slowly transforms from a potentially dangerous organization into a subject of an investigation sustained only by rumor, never anchored by proof. By the time the July 4th weekend arrives, the FBI's case has thinned into silence. What began as a chase for a possible murderer hidden within a migratory commune, ends not with an arrest or a revelation, but with the gradual realization that the story that triggered the inquiry cannot be substantiated. The Rainbow family remains what it was before the rumors took hold, a loose, drifting countercultural gathering, misunderstood by some, watched by many, but in the end, never the threat imagined at the investigation's outset. 1985 to 1986, cult/child endangerment rumors and missing children angle. The story opens in the woods. In the summer of 1985, sheriff's deputies in Warren County, Pennsylvania, were patrolling the back roads and logging tracts of the Allegheny National Forest, watching the early stirrings of a camp that did not look like anything in their training manuals. The Rainbow family gathering of the tribes was setting up, painted buses, dusty vans, people on foot with backpacks and drums, kitchens taking shape beneath tarps. Somewhere along those roads, deputies stopped a man whose name is now buried under black ink. They took his details, noted his connection, real or perceived, to the Rainbow family, and passed the information up the line. At the time it was nothing more than a roadside encounter in a remote forest, but in the FBI's files it would later become the seed of a case labeled NY 79-1481. Nothing much happened immediately. The Rainbow camp came and went. Local officials were wary but mostly focused on sanitation, traffic, and whether this crowd of hippies would leave the forest as they found it. A Times news feature from Erie described the scene in benign detail. Communal kitchens with names like Earth Mother's Kitchen, families and drifters talking about peace and spirituality, and a leaderless structure that relied on tribal councils and consensus rather than formal authority. One bearded man explained the gathering as a continuation of 1960s ideals. Another, calling himself a hobo and rail rider, talked about years on the road and the way Rainbow gatherings gave him a kind of moving home. The photograph showed people cooking and talking, not a criminal conspiracy. Yet, in other files the FBI already held fragments from earlier years. A confidential source had once described a rainbow-linked address in New York as a Manson-type cult, repeating slogans like everything for everybody and hinting at drugs and darker undertones. Those older notes sat uneasily beside the newspaper's pastoral language, and that tension, between rumor and visible reality, would run through the entire investigation. The real trigger came a year later. On June 18, 1986, Sheriff Donald Allen of Warren County received a phone call that did not sound like the usual local complaint. The caller, a man whose identity is now fully redacted, said he belonged to an organization devoted to finding missing and sexually exploited children. He claimed his own investigation pointed toward the Rainbow family. According to him, there might be a link between certain missing kids and the people who came to those forest gatherings. He wanted to come to the upcoming Rainbow event in Warren County in an undercover capacity, blend into the camp, move among the tents, and look for children who should not be there. He gave a name, a telephone number, and enough polished confidence to stand out in the sheriff's memory. Allen passed the information to the FBI. The Pittsburgh field office relayed it to the Erie resident agency, and within days an FBI supervisor in New York was hearing about a commune-type or cult-type group made up of hippie-type individuals from the 60s era that might be holding children inside a commune said to number more than 7,000 people. By June 17, 1986, a handwritten memorandum in the New York office was recording the allegations in nervous script. There were claims that children were kept within their commune, that an unnamed organization financed the group, that someone believed to live in a certain area was involved, and that the Rainbow family might be more than a loose circle of drifters. The memo closed with a decisive line, In light of the reported information, a new case under the 79 classification would be opened. The file number 79 to 1481 was officially born. From that moment, the investigation followed the pattern of many FBI inquiries that start from rumor rather than a specific crime. The first tasks were bureaucratic but necessary. Find out who these people were, whether they had records, and whether any other office had touched them. Agents at the Rego Park Resident Agency in New York pulled older serials from 1983 and 1985, combing through previous mentions of rainbow-related names supplied by confidential sources. One Michigan State Police detective had told the Bureau that the Rainbow family was also known under an alternative organizational name, suggesting a more structured entity behind the communal facade. Another source claimed the group was an international outfit heavily involved in drugs, with a particular person in charge. Each detail sounded authoritative in isolation, but everything crucial, names, addresses, the source's own identity, was now crossed out in thick black strokes. What remained on the page were hints of a sinister hierarchy overlaid onto what locals mostly saw as a wandering festival. Meanwhile, Erie agents tried to anchor the case to real people in real places. Sheriff Allen had told them the Rainbow family planned to return to Warren County for a July 1 to 7, 1986 gathering, with 5,000 to 10,000 people expected in the forest. The Pennsylvania State Police were already preparing a command post. Somewhere among those thousands, according to the sheriff's recollection, would be the mysterious caller who wanted to come in undercover. New York sent a teletype asking that this man be interviewed, either by the Buffalo office or the Erie Resident Agency. An agent assigned to the case said he would attempt to meet the caller at the gathering site itself once the camp was fully established. Agents also tried to run the caller down through his telephone number. A special agent dialed it and got only a recorded message. The message confirmed the number was the same as the one given to Sheriff Allen, but it did not lead to a person, only a disembodied voice. Repeated attempts produced the same result: a machine, not a man. There was no home address, no office, no simple way to serve a subpoena or knock on a door. In an era when answering machines were new enough to feel impersonal and evasive, this technological distance added to the unease. The key informant of the case could not be questioned, he existed only as a recording. At the same time, the search widened toward the man stopped by deputies during the 1985 gathering. Erie passed that stop to New York, the subject's name, later redacted, his appearance, and the sheriff's suspicion that he might be someone else, a person connected, in some ill-defined way, to rainbow-related rumors. A New York agent compared the Warren County information with older files and concluded that the man stopped in the forest appeared to be the same individual who had surfaced in earlier reports about rainbow circles. That, at least, gave the Bureau one living, traceable person connected both to the gathering and to confidential source reporting. To figure out what kind of risk, if any, this man posed, New York turned to standard tools. An NY-32 form went out on July 10, 1986 to Police Commissioner Benjamin Ward at NYPD, requesting a full criminal history on the subject, including photographs. The form listed the man as a white male, 5'11", brown hair, linked to an Eastside number, and asked for any prior arrest information. Another NY-34 letter requested listings on additional subjects whose names are now entirely blacked out. A record request form FD-125, marked criminal, went to the FBI's own records unit and came back with results that are themselves redacted. Internally, Brooklyn Queens staff ran automated index searches, stamping pages was searched, serialized, indexed, and filed, converting fragments of rumor into tidy case management entries. While these record checks churned in the background, the Bureau sought to understand the Rainbow family itself, and for that, it leaned heavily on open sources. Pittsburgh forwarded to New York an Erie Times News Sunday edition from June 22, 1986, the one that ran a long feature titled "Rainbow People Arrive." The article described a leaderless family that chose gathering sites by consensus, cooked communal meals in forest kitchens, maintained medical stations and children's villages, and banned alcohol while tolerating drugs in an informal, uneven way. Participants spoke of spiritual community, freedom from commercial life, and the long shadow of the 1960s. The story noted that most Rainbow people used trail names rather than legal names and often refused to be photographed. One child, when asked, reportedly said that if someone took her picture, her soul would not be able to leave the earth until the photo was burned. From a security perspective, this anonymity worried officials, but nothing in the article hinted at systematic child exploitation. Another clipping, rainbow people invade Allegheny Forest, painted a similar picture of colorful buses, long hair, beads, and peace symbols converging on the forest for what was billed as a celebration of world peace and sharing. Local reaction was mixed. Some editorials compared the visitors to gypsy moths, fearing they would strip the area bare and move on. Others conceded that past gatherings in places like West Virginia and the Mark Twain National Forest had come and gone without major incident, aside from occasional conflicts over wildlife or land use. The Rainbow Camp's own peacekeeping force, the Shanty Sena, was described as a kind of internal mediation corps. When a bear was illegally killed near one gathering, Rainbow members claimed they were as unhappy about it as the authorities. Inside the FBI, there was a clear disconnect. Confidential sources and earlier memos spoke of an international outfit, a cult with a charismatic figure in charge, heavily involved in drugs and perhaps worse. Contemporary newspaper reporting and on-scene observation depicted a messy but mostly peaceful countercultural festival. The missing children allegations, which had initially justified the case, remained lodged in a single phone call from a man no one could find. There were no specific names of victims, no case numbers from local police, no parents calling in parallel to say their children had disappeared into the woods. Through the summer of 1986, an agent at the Erie Resident Agency kept trying to close that gap. According to a memorandum eventually filed on September 23, all efforts to locate and interview the caller in the Erie area failed. Every call to his number reached only the answering machine. Field attempts to find him at addresses or locations associated with his name went nowhere. At some point, new information reached the Erie office suggesting that another individual, also redacted, might be a bounty hunter or private investigator of some kind trying to track down yet another person, someone who had allegedly passed himself off as a Rainbow family member. The memos hint at a small web of people who might have been using the Rainbow name for their own purposes, one trying to infiltrate, another possibly impersonating, none of them clearly part of the Rainbow family itself. The agent chased those leads as far as they would go. One redacted subject was believed to be driving a particular vehicle, but surveillance or spot checks failed to find either man or car. Record checks came back with negative results on the key identifiers that could have tied any of these figures to known offenders or open missing person files. The man stopped at the 1985 gathering remained only that. A man stopped once in the woods, with no clear criminal history that matched the rumors. By early autumn, the case file had become a stack of paper reflecting a great deal of motion and almost no traction. There were airtels between Pittsburgh and New York, investigative summaries from the Rego Park office, criminal history requests to NYPD, open-source clippings about rainbow gatherings, and pages of handwritten notes pierced by hole punches and streaked with FOIA redactions. There was not, however, a single corroborated incident of child abduction, sexual exploitation, or organized criminal conduct tied directly to the Rainbow family. Whatever one thought of thousands of hobos and hippies camping on federal land, they were not, in the Bureau's hands, turning into a solvable or even definable case. On September 23, 1986, the New York office put the situation in plain terms. In a memorandum titled Unsubs, aka Rainbow Family, the reporting agent wrote that all attempts by the Erie RA to locate and interview the central subject had been unsuccessful, and that every effort to nail down the leads had produced negative results. Another passage, now mostly blacked out, recorded the belief that one of the people involved might be using the Rainbow name as cover while hunting for someone else entirely. With no subjects they could find, no crimes they could prove, and no victims they could name, the agent recommended that the matter be administratively closed. There was nothing more to do. The Bureau kept track of the paper trail a little longer. In August 1987, an investigative note summarized yet another piece of information from a source about a man thought to be connected to a certain role or credential, but the follow-up again faded behind redactions and routine processing stamps. The file's later pages show closed scrawled across forms and automated record checks boxed off for archiving. What began with a single stop on a forest road and an unsettling phone call about missing children ended, a year later, as a portrait of suspicion that never found its object. The Rainbow family remained what it had been in the public eye, a roaming, disorganized gathering that unsettled local authorities, fascinated reporters, and, for a brief period in 1985 to 1986, drew the FBI into a hunt for threats that never quite took shape. 1990, the Oak Ridge, Y-12 threat that collapses. The first clue dropped in April 1990, in the Louisville field office, and it did not look like much at first. A confidential source who had been talking to the FBI about drugs since 1988 suddenly shifted topics. Instead of the usual street-level intelligence, the source began talking about a loose itinerant group known as the Rainbow Family of Living Light, and hinted that some of its members were talking about doing something at the Department of Energy's Y-12 nuclear weapons plant in Oak Ridge, Tennessee. There was no bomb design, no target map, just fragments, talk of certain people in the family, talk of Y-12, and enough suggestion of malice that the Louisville agents felt they could not ignore it. They wrote it up and pushed it out as an Atomic Energy Act matter, sending a teletype to FBI headquarters and to Knoxville, the office responsible for Oak Ridge. From the beginning, the record shows a tension between urgency and doubt. Louisville framed the source as someone they had relied on since August 1988, a person who supplied criminal intelligence and was not motivated by money. Headquarters asked the standard questions. How reliable has this source been? Is this new report an isolated tip or part of a pattern? Can the source get more? Louisville answered in the language of informant files, stressing past reliability but also making clear that all of the new threat information came from this one person alone. To protect the source's identity, the Bureau redacted almost every substantive sentence in later copies of those messages, but the structure is visible. Source is, as previously reported. Source advised. Followed by solid black bars. It is a classic sign of a case trying to walk a tightrope between acting and overreacting. Knoxville, meanwhile, had a more practical problem. If something was brewing against Y-12, DOA security needed to know. In a late April teletype, Knoxville told headquarters it was trying to decide what exactly to tell the Department of Energy. Agents asked Louisville for a tighter assessment of the source and a clearer sense of whether there really was a conspiracy here or just alarming talk. The internal notes show that the Bureau wanted to contain the circle of knowledge while it sorted out the facts. Even at this stage, however, the information was already starting to seep outward through phone calls between FBI agents and DOE safeguards personnel at Oak Ridge. In May, the case picked up additional color but not much substance. A U.S. Park Service employee at Big South Fork National Park in Tennessee sent in his own impressions of a rainbow gathering he had been told to monitor. He thought the whole thing looked drug-based. People wandered around under the apparent influence of LSD, engaging in behavior he described as prolonged and unusual. There were some minor possession arrests, but no big seizures, no search warrants, and nothing that looked like an organized trafficking operation. Asked directly about the potential for terrorist violence, the ranger gave an equivocal answer. Some individuals seemed unpredictable and capable of extreme acts, but he did not know the group well enough to say anything coherent about its intentions. It was atmosphere, not evidence. At headquarters, the lawyers and counterterrorism supervisors were worried about a different kind of risk. The Rainbow Family was, in essence, a countercultural camping movement organized around gatherings and shared beliefs, not a recognized terrorist organization. Any FBI inquiry into it raised First Amendment alarms. When Louisville asked for permission to use an electronic recording device so its confidential informant could tape conversations with Rainbow members, the request went all the way to the director's name on the approval line and came back with a firm no. A late May teletype reminded Louisville that the investigation could easily impact First Amendment-protected activities of innocent members, and that the Bureau could not justify wiring up an informant just to listen to what people said at campfires and meetings. The message instructed the field offices to stop treating the matter purely as an Atomic Energy Act case, and instead to open a domestic security/terrorism preliminary inquiry, codenamed Darkglow, limited to a suspected violent faction, not the Rainbow Family as a whole. Headquarters then laid down conditions. If Louisville wanted any form of consensual monitoring, it had to demonstrate that normal techniques would not work, explain exactly what kind of meetings were being targeted and where they took place, and show that the subjects were clearly identified individuals, not a vague category of rainbow people. Agents were ordered to describe who these subjects were, what roles they played in the group, how they interacted with others, and under what circumstances any monitored conversations would occur, whether in private homes or public campgrounds. The directives read like a checklist designed to fence the case in, focus on specific suspects, avoid scooping up information about beliefs, assemblies, or speech, and minimize any adverse impact on those who were merely exercising their rights. While the Bureau was trying to keep the lid on, the Department of Energy was already rattled. On May 22, DOE headquarters reached out to the FBI to ask what was going on. DOE had issued a warning notice to its facilities about a potential threat tied to the Rainbow Family and the Y-12 plant. FBI headquarters, still treating Darklo as a fragile early-stage inquiry, told DOA that the matter was sensitive and that no further details should be spread around. The same guidance went back down the chain. Knoxville was told to contact a specific DOE official and make clear that this was not something to circulate beyond those with an absolute need to know. That admonition would prove necessary, because DOA later admitted that it, not the local Oak Ridge security officer, had made the decision to widely disseminate the early information. By early June, the case file shows the investigation turning inward, testing its own foundations. In one entry, a Knoxville official notes confirming by phone that there was no identifiable connection between two of the redacted subjects who had figured in the informant's story. In another, a national park ranger recounts a peculiar call from a private individual who claimed to have checked out one of the subjects and found him trustworthy, hinting at ties to the company and the FBI while insisting he was not an agent himself. Whatever details the caller provided are blacked out, but the impression is of rumor and self-importance, not solid corroboration. The critical effort to verify the original source came in the form of a polygraph. A June 27 teletype reports that a polygraph exam of a redacted subject, tied to the confidential informant's claims, produced results that are themselves redacted, but the summary that follows is clear. Louisville could not corroborate what the source had said, and the source's reliability was now in serious doubt. The alleged incident the informant had warned about was supposed to occur on a particular date, and that date had come and gone with nothing happening at Y12 or any other DOA site. With no attack, no arrests, and no physical evidence, the entire structure of the case rested on an informant whose story was no longer trusted. Even as the substantive threat evaporated, the bureaucracy kept moving. On June 4, a Knoxville agent called DOA safeguards at Oak Ridge to emphasize the sensitivity of the matter and to ask that it be kept close hold. 2 days later, the same office learned that DO headquarters had already pushed the warning out broadly, a decision that could not be undone but that DOA now promised not to repeat. In July, a separate strand of the paper trail appears from New Haven, Connecticut. DOA had written to the FBI office there asking it to check its records on the Rainbow family because of the Y12 concern. New Haven responded that it had nothing, no Rainbow case files at all, and conveyed that answer both in writing and by phone. An internal routing slip from mid-July then shows that one of the airtels in the matter was misrouted to Memphis instead of Knoxville, a mundane error that nevertheless underscores how far the worry had spread within federal channels compared to the thinness of the underlying facts. By late July 1990, the Knoxville office had had enough. In an airtel to headquarters, it recounted the chain of events, the Louisville source's allegations about a handful of Rainbow family members, the DOA security anxieties, the Park Service observations, the internal restrictions from headquarters, and the failed attempts to corroborate any of it. The key points were simple. The only real threat information came from one confidential informant. Efforts to check that informant's claims, including the polygraph, had not supported them. The supposed target date had passed quietly. No additional intelligence suggested any continuing plot against Y12 or any other DOA facility. On that basis, Knoxville recommended closing not only the preliminary inquiry it had opened in May under the Darklo caption, but also an earlier preliminary inquiry that dated back to April and was tied to the same core allegation. Headquarters agreed. The preliminary inquiries were closed in June to July 1990. And the remaining paperwork, declassification stamps, routing slips, and final administrative notes, finished the file. What began as an alarming hint of a threat against a sensitive nuclear facility ended as a case study in institutional nerves, informant management, and civil liberties caution. The FBI had treated the Rainbow family of living light as a potential danger long enough to satisfy DOE and in its own counterterrorism obligations, but not long enough to turn scattered suspicions and drug use anecdotes into a full-blown domestic security case. Once it became clear that there was no evidence of organized violence and that the informant's story could not be trusted, the Bureau let the matter go and consigned Darklo to the archives. 1990 to 1997, Drug Trafficking Rainbow Network Narrative. By the time the Little Belanca single-engine aircraft limped into Dubois Jefferson County Airport in rural Pennsylvania on August 3, 1995, Eugene Earl Hector was already a name in government files from California to Washington, D.C. For years, bits of intelligence about him and the loose, roaming subculture called the Rainbow family had been piling up in DEA reports, customs cables, FAA security alerts, IRS notes, and local narcotics files. To one agency after another, the Rainbow family of the Living Light, Rainbow Nation, in some reports, no longer looked like a ragged crowd of hippies who met in national forests. It looked like a ready-made network, transient people, off-the-grid camps, and cash-only economies that could be used as a smuggling and distribution web running from Mexico deep into the United States. Sitting in the center of this picture, in the eyes of investigators, was Hector, an ex-convict pilot with a history of aviation violations and suspected to be moving drugs by air. On the ground in Pennsylvania, the case began with a tip that an odd airplane had taken to visiting Dubois. In May 1995, a state trooper attached to the Region 4 Strike Force learned that a particular aircraft had been dropping in, taking fuel, and disappearing again. The tail number and registration details, now buried under black redaction bars, did not look right. When the trooper checked with FAA security, the picture sharpened. The plane's triennial registration report was delinquent by more than 2 years. The aircraft had a history of trips to Mexico, and its operator had drawn attention for filing false flight plans and ignoring orders. Customs and California police units, when contacted, confirmed the trooper's unease. They said the same man had prior drug arrests, from marijuana smuggling to cultivation, and that he was tied to the Rainbow family. A confidential informant added one more piece: that this particular aircraft was believed to be hauling controlled substances. From April through July, the trooper and airport staff quietly watched as the Blanca returned again and again to Dubois, refueling and departing with no obvious legitimate business to explain it. Then, in early August, the call came in. The mystery aircraft was back on the ramp. The trooper drove out to the airport to see it for himself, a 1965 Blanca Downer, a worn single-engine plane with a tail number that matched the one FAA had been warning him about. As he watched, a white male pilot and a female passenger moved around the plane. The registration problem was now more than a bureaucratic note. The aircraft, on paper, should not have been flying. With federal guidance in mind, how to spot smuggling flights, what patterns to look for, he decided to act. He brought in a PSP drug-sniffing dog and approached the scene. The pilot identified himself. The passenger did the same, and when questioned later, both would describe themselves as Rainbow family members, part of a counterculture that embraced marijuana, LSD, and other psychedelics. The encounter quickly turned tense. The trooper obtained consent to search personal belongings, but not the aircraft. He notified the pilot that because the registration was expired, the plane was not going anywhere. Over the next short span of time, the pilot kept trying to get back to the Blanca, ignoring instructions to stay away. To the trooper, this was more than nerves. It was the behavior of someone desperate not to have whatever was inside that plane examined. Eventually, the trooper arrested him for trespassing, a straightforward state charge that nonetheless gave the police physical control of both the man and the aircraft. While this played out, the PSP dog worked the area and alerted positively on the Blanca, giving the trooper probable cause to seek a search warrant. Once the warrant was in hand, the hangar doors opened on the real heart of the case. Inside the aircraft, investigators found several large duffel bags. When they were unzipped, they were packed with dried mushrooms. They were sent to the PSP Regional Laboratory in Erie, which reported back that the haul weighed 36.8 kilograms, about 81 pounds, and contained psilocin, the active compound in certain hallucinogenic mushrooms, a Schedule I-controlled substance. Along with the mushrooms, police collected a handheld GPS unit wired into the cockpit, and from the pilot and passenger they took records, a checkbook, and a rented Canon laptop computer that one of them reportedly fretted over, saying it held names of Rainbow family members and personal journal entries. On paper, the charges were simple: possession and possession with intent to deliver psilocin mushrooms. In practice, the case already looked much larger. As the state charges moved forward, the FBI stepped in. On September 13, 1995, Pittsburgh opened Case 281 FPG 61773, formally tying the Dubois seizure to its growing file on the Rainbow family. The opening memorandum recited the chain of intelligence, DEA and Customs noting that Hector and his associates had been operating for years, FAA records showing repeated aircraft violations, a 1993 DEA publication describing how rare large psilocin seizures were, and estimating that a load of this size carried a wholesale value around $150,000 and a street value over $500,000. and reports from California task forces describing the Rainbow family not as a loose spiritual gathering but as a drug trafficking organization whose members had already turned up in investigations ranging from marijuana smuggling to LSD distribution and even homicide. Within that framing, the Blanca was not just a plane with contraband, it was a suspected smuggling platform for a long-running network. To move the case into federal court, the Bureau needed more than suspicion. The Assistant U.S. Attorney in the Western District of Pennsylvania agreed that the facts fit a serious federal drug trafficking statute, but she would not adopt the case without the blessing of the local district attorney. When the Jefferson County DA raised no objection, the path opened. Agents began building the federal case in layers. They worked with the Pennsylvania State Police to document every step of the seizure and arrest, pulled aircraft registration records through onlets, and confirmed that the Blanca was indeed a 1965 Downer manufactured Model 14193A, registered in California. An FBI agent examined the aircraft in its Beechwood Flying Service hangar, paint scraped and chipped along the belly and landing gear, a rear cargo door that no longer closed cleanly, patches and repainting around the tail number suggesting hard flying and rough handling. There were no maintenance logs or flight records in the cabin, an absence that would later haunt the forfeiture case. The agent photographed everything, plane, hangars, taxiway, terminal, to freeze the scene as evidence. Next came the electronics. On November 17, 1995, a federal magistrate signed a search warrant authorizing examination of the Canon laptop and a Casio BOS electronic organizer seized at the time of the arrest. The laptop, with its accessories, disks, and manuals, went to FBI technical personnel in Baltimore. The BOS organizer and its manual were shipped to the Electronic Analysis Unit at Quantico. Laboratory specialists began the careful, methodical work of digital forensics, checking directory structures, opening files, and looking for anything that resembled ledgers, contact lists, or coded messages. An investigative analyst conducting a quick spot check of the laptop in January 1996 noted references to marijuana, drug slang, and possibly coded terms that would only make sense to someone familiar with Hector's circle, as well as a manuscript-like text in a simple text editor. The Casio device turned out to be less dramatic. Examiners reported that its secret password-protected memory had never even been activated. While this technical work continued, the legal side advanced. On December 5, 1995, another magistrate judge issued a federal seizure warrant for the aircraft and the laptop system, clearing the way for formal forfeiture. The next day, an FBI agent drove back to Du Bois, taped the warrant to the inside of the Blanca's windshield, and handed a copy to the Beechwood Flying Service representative. The small company, which had been charging about $60 a month to keep the derelict plane stored and minimally maintained, estimated its market value at around $25,000, with the missing logbooks likely to drive that figure down. The Bureau valued the laptop and peripherals at roughly $2,000. Internally, memoranda circulated about how to split any forfeiture proceeds with the Pennsylvania State Police and how to cure a technical problem. State law required a request for adoption of state/local seizure within 30 days of the seizure date, but the formal adoption request had lagged, forcing FBI lawyers to ask PSP to submit retroactive paperwork explaining the delay. The case moved into a new phase in January 1996, when a federal grand jury in Pittsburgh handed up an indictment against Hector on a single count of possession with intent to distribute psilocin mushrooms. A federal magistrate issued a bench warrant. Hector, meanwhile, was not in hiding. He returned to Pennsylvania for a suppression hearing on the state charges, still believing that the legal fight was about what had happened at Du Bois that summer. Federal agents saw an opportunity. After a flurry of communications between Pittsburgh, Los Angeles, and Sacramento field offices, alerting them that Hector was now wanted, considered armed and dangerous, and believed to be living in California, they learned that they would not need to chase him down on the West Coast after all. On January 29, 1996, as he arrived at the Jefferson County Courthouse in Brookville for his scheduled hearing, state police and FBI agents took him quietly into custody. As sometimes happens in high-profile narcotics cases, the newspapers quickly folded the story into their own narrative. Articles from the Courier Express and the Tribune Review described Hector as a California man arrested in connection with one of the largest magic mushroom seizures in years, emphasizing the 81-pound weight of the haul and its hallucinogenic nature. Reporters repeated details from Trooper Gordon Watt's testimony, how he had been tipped off about the plane, how conversations with FAA officials and data from the El Paso Intelligence Center had marked Hector's aircraft as a target plane linked to smuggling, how the expired registration had given him a lawful basis to hold the aircraft, and how guidelines for spotting drug-running aircraft had informed his decisions. The stories also mention the Rainbow family, portraying it as a Southwestern-based organization committed to psychedelics and legalization, echoing the language found in federal reports. At detention hearings, Watt told the court he wanted the case in federal court precisely because the penalties there were far harsher than under Pennsylvania law. But away from the headlines, defense attorneys were already probing the weak points in the government's chain of events. They questioned whether holding the aircraft solely because of an expired registration was lawful, and whether the sequence from detention, to the dog sniff, to the search warrant had respected constitutional protections against unreasonable searches. They also argued that some of the intelligence information that had driven Watt's suspicions would never have been admissible at trial under stricter evidentiary rules. These challenges gathered force, and on February 13, 1997, according to a Tribune Review article later mounted in the FBI file, U.S. District Judge William Standish ruled that most of the mushroom evidence would be suppressed as the product of an illegal search. With the core of the case excluded, federal prosecutors were left with virtually nothing with which to proceed against Hector. For the FBI and its partner agencies, the outcome was deflating. Throughout the file, they had painted a picture in which the Rainbow family served as a ready-made logistics chain for drug traffickers, and Hector's Belanca as a flying link between psychedelic growers and far-flung markets. They had devoted months to cross-checking databases, shuttling electronics to laboratories, negotiating forfeiture details, and coordinating field offices across multiple states. Yet in the end, the evidentiary center of their case collapsed on constitutional grounds. By May 1997, Pittsburgh's Johnstown resident agency drafted a final communication to the Santa Maria resident agency in California. Case 281 FPG 61773 was closed. An envelope of background material was sent west, and the Rainbow family investigation associated with the Dubois seizure moved from an active file to a historical one, still reflecting an institutional view of the Rainbow gatherings as a narcotics concern, but with the flagship prosecution that was meant to prove it left stranded, its key evidence legally unusable. 1999 to 2001, Counterterrorism Preparedness Special Event, then closure. The file opens like a case dumped on a desk, a thick stack of forms, clippings, and redacted pages, all orbiting a single question the Bureau never quite states out loud: what, exactly, is the Rainbow family, and are they a threat or just an administrative problem someone has decided looks like one? The first sheets fix the frame. In June 1999, the Pittsburgh Division opens a case tagged 300 APG 66432 and files it under domestic terrorism, counterterrorism preparedness, for an upcoming North American rainbow gathering in the Allegheny National Forest. The bureaucratic language is dry, but the label matters. To the FBI, this is now a special event to be monitored like a summit or a high-risk protest. The same pages, though, describe the target in oddly loose terms: a non-organization with no leaders, no membership, no structure, an outgrowth of the 1960s hippie movement that promotes nonviolence, alternative lifestyles, and large temporary communities on public land. The narrative notes drugs, runaways, and fugitives, but the tone reads less like a dossier on a cell and more like a profile of a traveling culture that does not fit any box the Bureau owns. Buried under that 1999 label lies an older thread. In Knoxville, Tennessee, back in 1990, someone had come to the FBI with allegations serious enough to open a case file. A source pointed at the Rainbow family and claimed something worth investigating. The details now sit behind black ink. The Bureau took it seriously enough to schedule a polygraph. When the wires and sensors were removed, the results undercut the entire story. The source's reliability collapsed, credibility questioned, and within a few months the Knoxville office shut the file. Yet the closure did not erase the subject. Instead, it left a ghost entry, an old investigation with no substance but a live case number, parked in the FBI systems. Nearly a decade later, when the Allegheny gathering appears on Pittsburgh's radar, that Knoxville reference is still there, ready to be pulled into a new narrative even as internal memos note that it led nowhere. As plans for the 1999 gathering solidify, Pittsburgh begins to act like an office preparing for an operation around an unknown, mobile crowd. In early June, an unclassified but tightly formatted message goes out to all field offices, flagged for assistant directors in charge and special agents in charge. The subject line is neutral: intelligence regarding the Rainbow family and the upcoming gathering, but the classification code is not. The event is again slotted under counterterrorism preparedness. The body of the memo recites the same description: a massive, leaderless non-organization that has been meeting on public land since the early 1970s, drawing 15 to 25,000 people each summer. Participants are sketched as aging hippies, nomads, vegetarians, nudists, and those who reject mainstream values. Alcohol is officially discouraged, the memo notes, but herbal drugs and psychedelics are widely used, and marijuana and mushrooms are commonly present. The tone is clinical, yet the effect is to frame the gathering as a potential magnet for lawbreakers, even when the document stops short of alleging anything like terrorism. The same communication sketches what the Bureau actually fears might happen. The previous year's gathering in Apache Sitgreaves National Forest in Arizona, it reports, produced numerous local arrests and several fugitive arrests. The FBI is not saying the Rainbow family is a conspiracy. It is saying that wherever tens of thousands of transient people assemble, some wanted fugitives and opportunistic criminals will be among them. That is enough to justify surveillance and coordination. The memo explains that the U.S. Forest Service expects 25,000 attendees in the Allegheny National Forest, which sprawls across Warren, McKean, and Elk counties. Pennsylvania State Police will stand up a joint command post with the Forest Service at the Sheffield Ranger Station. The Rainbow family, the Bureau notes, is using the internet to spread the word and organize. What the memo wants from the field is simple: positive source information only. Offices are instructed to query informants, report anything concrete to the Erie Resident Agency, and route tips about fugitives directly to Pittsburgh, which is running a fugitive task force. Inside Pittsburgh, someone asks a basic question that, in a detective novel, would be the pivot: have we ever seen these people connected to terrorism at all? On June 29, an internal communication records an FIA database review. Analysts pull up the Knoxville file from 1990, look at its redacted content, and then state plainly that there is no indication in FBI systems linking the Rainbow family of living light to the sensitive category under review. The same memo recounts how Knoxville opened its case on May 29, 1990, based on information from a source, then closed it after the polygraph undermined that source's credibility. The Bureau is, in effect, reminding itself that the most concrete prior lead about the Rainbow family collapsed under scrutiny. Yet the case file remains coded as a domestic terrorism-related special event. Institutional caution has outrun the facts. Around this bureaucratic core, a completely different kind of evidence accumulates: newspaper clippings from small Pennsylvania papers, carefully mounted on FBI forms. These are not intelligence reports, they are snapshots of how the gathering looks from the ground. One early June article from the Erie Times-News, headlined about police warning of a coming Rainbow meeting, tells readers that more than 20,000 non-members will soon descend on the Allegheny National Forest, that state police advise awareness but not panic, and that the Rainbow family is informal, leaderless, and largely made up of aging hippies and free thinkers who share food and campfire conversations. Another piece continues under the subheading, "Expect Some Problems," where Trooper Jim Rogers addresses town meetings. He tells residents to expect shoplifting, gas drive-offs, and minor property crimes simply because the local population will temporarily double. He warns about drug use, speaks pragmatically about nudity within the encampment, and emphasizes that most crime will spill outward, not occur in the woods themselves. In Johnsonburg and Ridgeway, the story becomes less abstract. Public meetings draw dozens and then more than 100 residents, business owners, and officers. Forest Service officials try to reassure them. Resource specialists talk about endangered species, delicate watersheds, and the practical limits of a rural county's law enforcement, retail capacity, and health infrastructure. Local people ask why gates that are usually locked are open now, and why the same rules do not seem to apply. Some are anxious that a group which refuses to sign permits can still bring 25,000 people into a forest whose roads and services were built for small towns. The Forest Service answers that the land is public, that the area has been declared a shutdown zone for normal use but open for event parking, and that realistically, there is no way to prevent a leaderless gathering from arriving, only to manage its effects. Within those meetings, Rainbow family members step forward and speak in their own defense. One woman stresses that the gatherings are self-sustaining and peaceful, that many attendees are parents and grandparents, and that crime rates, on a per capita basis, compare favorably with cities. Another, identified as Turtle, explains the internal economy: no cash registers, no official vendors, just bartering and voluntary contributions, with each person asked to bring their own basic utensils. They describe the shanty scena, a volunteer peacekeeping group that handles disputes and safety problems from within, and CALM, Center for Alternative Living Medicine, a loosely organized medical corps that claims a good safety record and cooperative relationships with ambulance services when needed. Their account presents the gathering as a temporary town with its own customs, not a mob. At the same time, an official story about law and authority moves on its own track. A Forest Service incident commander, Bill Fox, tells reporters that not all rainbows follow their professed ideals, that a tough group within causes trouble, and that a camp, an alcohol-heavy fringe camp near the road, has been the source of past problems. The Forest Service brings in a national incident management team from other states, along with dozens of vehicles, to prepare for the influx. Articles describe the logistics: seed camps arriving early to scout meadows, debates over which site is too marshy or too fragile, resource experts walking the terrain with rainbows to assess impact, and bulletins warning that springs and creeks are unsafe to drink without treatment. The Forest Service repeats a simple line: they cannot manage the gathering itself, only its environmental and public health effects. Over the summer, the focus tightens onto one legal friction point: permits. Federal regulations require a special use permit for groups larger than 75 on national forest land. The Rainbow family insists there are no leaders to sign anything and no one individual who can assume legal responsibility for thousands of strangers. The Forest Service insists that someone must. Eventually, 3 people, Garrick Beck, Joan Kolb/Kolbull, varying by clipping, and Stephen Sedlacko, are cited as de facto leaders for failing to obtain a permit for a gathering that has drawn around 20,000 people. They are not arrested but summoned into federal court. The charge is a misdemeanor, technically carrying a possible 6-month jail term and a $5,000 fine, though press accounts note that similar cases have ended in token fines around $50. For the defendants, the stakes are less the money than the precedent. They argue that the permit framework itself is unconstitutional when applied to a leaderless assembly, because it makes a handful of individuals legally accountable for a mass of autonomous participants they do not control. While that case moves forward, another courtroom hundreds of miles away has already rendered a judgment on related tactics. A 1999 clipping recounts how senior U.S. District Judge Russell Clark, ruling on a lawsuit from a 1996 Missouri gathering, held that Forest Service checkpoints and roadblocks aimed at rainbow participants violated the Fourth Amendment. Clark's opinion is blunt: targeting a specific group near its gathering and subjecting it to blanket stops and searches amounts to a shakedown and should alarm any citizen who cares about personal liberty. The decision does not bless the Rainbow family, it limits the government. Roadblocks are acceptable for narrowly defined purposes like sobriety or border checks, not as general tools to police a lifestyle or a subculture. That ruling hangs in the background of the Allegheny file like a legal boundary line the Forest Service and FBI must now not cross. By September 1999, the permit case in Pennsylvania has become complicated enough that the scheduled trial before a magistrate judge is postponed. The defendants elevate their challenge to the U.S. District Court, contesting the constitutionality of the charges. A local paper reports that they are outspoken, firmly rejecting the notion that anyone can be a leader of the Rainbow family, and that they are willing to test the issue in front of an Article III judge. No new trial date is announced. The gathering itself is over. Forest roads that carried thousands of vehicles in late June and early July return to their usual traffic, and the small towns around the Allegheny National Forest slide back toward routine, albeit with stories about shoplifting scares, unexpected visitors, and long public meetings that went late into hot summer nights. Inside the FBI, the momentum also slows. For nearly 2 years the case file sits, thick with clippings, memos, and redacted inserts, an open pending matter attached to a one-time event. Then, on June 11, 2001, Pittsburgh sends a short communication to itself. The subject line repeats the long formal title: Rainbow Family of Living Light, North American Rainbow Gathering, Allegheny National Forest, Pennsylvania, Special Event. The synopsis is just 3 words: to close case. The body notes that investigative activity related to the gathering has been handled under several internal classification codes, and then states, without qualification, that Pittsburgh is conducting no further investigation. No plot twist emerges, no hidden cell uncovered, no late admission that the Rainbow family was ever anything more than what the early descriptions claimed: a large, messy, often inconvenient countercultural gathering that strained small communities and existing legal frameworks but did not match the terrorism label assigned at the outset. The detective work, such as it was, ends with a simple administrative act: closure, and leaves behind a paper trail that documents, with unusual clarity, how suspicion can persist inside institutions even when their own files say there is nothing there. 2004. Another counterterrorism-flagged gathering, basically uneventful. The story begins with an absence. On the top of the FBI file, page 1 is not a report, not a memo, but a deleted page information sheet explaining that 15 pages are missing, sent away to the Department of Agriculture for separate handling. Whoever opens the folder first is told, in effect, that there is more to this story than they are allowed to see. It is a case about a gathering in the woods, monitored by federal agents, and already partly elsewhere, partly redacted. To understand why the FBI opened the file at all, you have to go back to the spring of 2004, when Sacramento Field Office typed up a route in communication dated May 12. The subject line is neutral, almost bureaucratic: The Rainbow Family of Living Light, 2004 North American Gathering, CT Preparedness, Special Events. Inside, however, is a short institutional biography of the Rainbow family, written for people who might never have heard of them. Since 1972, the memo explains, they have been holding large, loosely organized gatherings on national forest land to pray for peace, honor Mother Earth, and discuss political and environmental concerns. In the early years they drew around 6,000 people, by 2000, more than 20,000, the previous year in Utah, about 10,000. The crowd has changed over time, the memo notes. Still a mix of environmentalists, animal rights activists, and itinerant anarchists, but increasingly younger and more focused on partying. With the rising numbers has come more violence, drug use, and vandalism, enough that the U.S. Forest Service now brings a crisis response team to each national gathering. The spark for opening the case is a briefing given a few weeks earlier, on April 22, by a supervisory special agent out of the Washington Field Office, who has been pressed into an unusual role: Incident Commander for the Forest Service's National Incident Management Team. In that briefing, carried into the Sacramento memo almost verbatim, he lays out the geography of the Great Basin region where the 2004 gathering is expected to land. It is a hot, dry spread of western Utah, Nevada, and eastern California, including places with names that already sound like trouble: Mojave Desert, Death Valley, the Bonneville Salt Flats. Rainbow custom, he notes, is to choose the exact site late. A spring council will meet on June 7 to decide, and only then will the announcement go up on the Rainbow website. A smaller group has already met, somewhere about 25 miles east of Oroville, California, to scout for water, access, and space. The incident commander does not ask for FBI agents at the site. He does, however, relay a concern that among the thousands of peaceful campers are some politically motivated individuals whose ideologies could overlap with domestic terrorism. That concern is enough. Sacramento opens the case, assigns it to a named agent whose identity is now blacked out, and sends out leads. The lead sheet reads like a dispatch board in a control room. Headquarters Counterterrorism in Washington is told simply to read and clear. Field offices in Los Angeles, San Diego, San Francisco, Portland, Las Vegas, and Salt Lake City are given discretionary leads. The instruction is the same for each. This information is provided for awareness. Report any positive information only to Sacramento. Nothing about infiltration, nothing about active disruption. Just a watchful network stretching over the western United States, waiting for a massive, mobile campout to pick its final patch of public land. As the weeks pass, the investigation becomes a kind of digital stakeout. Agents track the gathering not with surveillance planes or undercover operatives, but by combing the Rainbow family's own communications. Sacramento circulates instructions on how to use the Rainbow website and its newsgroup. Go to the main page, click into the discussions, look for the latest scouting reports. There is a May 26 update saying that Northern California sites lack water and that scouts are looking farther south. Nevada locations are under consideration. Bureau of Land Management personnel are specifically told to pay attention, because the eventual site might land on or near BLM land and they will need time to prepare. At one point, an April 22 sign-in sheet from a meeting in Sacramento is attached to an email, then completely redacted in the release file, a silent list of names that once sat on someone's desk as a roster of who knew what, and when. On June 14, the file takes a sharper turn. An internal email circulates with the subject line "Possible Rainbow Gathering Site." The location, it says, has finally been posted, near the tiny town of Madeline in Lawson County, California. The message includes driving directions pulled straight from the Rainbow announcement. From Madeline, you go east on Blue Lake Road to Patterson Sawmill Road, follow the signs to Patterson Meadow, then continue east to Homestead Meadow. A second attachment is a one-page printout, seemingly from a welcome home site, confirming the dates, July 1st to July 7th, and repeating the route while adding a practical warning. Avoid County Road 64 because logging trucks use it heavily and accidents are a risk. Then there is the map. Someone, either an agent or a support staffer, has gone to MapQuest and printed a June 13, 2004 map of the region. It shows Madeline on a thin state route, surrounded by sparse place names, mills, tiny towns, features dotting the border between Lawson and Modoc counties and over into Nevada. Highway 395 snakes by in the west, Route 447 points off toward more empty land. The printout includes an advertisement for a label printer and a standard disclaimer that the map carries no warranty. But what matters for the case is that the FBI can now visualize the likely route of tens of thousands of people into the high desert forests. That piece of paper, with its grids and tiny fonts, is how the federal investigation sees the gathering, not as a festival, but as movement through infrastructure and jurisdiction. From there, the paper trail jumps in time. The file does not record daily updates, informant reports, or incident logs. Instead, the next substantial entry comes after everything is over, a closing communication dated August 18, 2004. It confirms that the 2004 North American Rainbow Gathering has in fact taken place, not at the meadows outside Madeline but at Bear Camp Flats in Modoc County, a shift that would have been invisible unless you were following Forest Service operations closely. The same supervisory special agent from Washington serves on scene as incident commander under the Forest Service's National Incident Management Structure. Any operational details, the document says, can be obtained from him directly, his name and contact now covered by black rectangles. The conclusion is stark in its brevity. The event, the FBI notes, generated no information of investigative interest. No terrorism plots uncovered, no federal criminal investigation needed. The case is recommended for closure. A copy is sent to the case agent. Stamps are added, uploaded, and handwritten notations confirm that the administrative work has been done. Whatever concerns had prompted the April briefing and the May leads have not materialized into anything the Bureau considers worth pursuing. Viewed from end to beginning, the file reads like a detective story whose mystery is whether there will be a crime at all. The investigators assemble background on an unusual, nomadic community. They map likely crime scenes that never quite become crime scenes. They coordinate quietly with another agency that actually runs the field response. They follow digital clues to an expected location that shifts slightly on the map, and then they stand down. The 15 missing pages, referred to agriculture, hint at more detailed Forest Service planning and perhaps on-the-ground assessments, but in the FBI's own narrative, the Rainbow family's 2004 gathering is ultimately logged as a special event that had to be watched, and then, after nothing happened that fit federal statutes or counterterrorism thresholds, carefully and formally closed. Institutional suspicion persisting despite repeatedly unsubstantiated threats. Across the 3 decades documented in these files, the relationship between the U.S. government and the Rainbow family settles into a pattern defined less by escalating conflict than by a cycle of suspicion, investigation, and eventual retreat. What begins each time as a potentially serious federal concern, subversion, child endangerment, attacks on a nuclear facility, large-scale narcotics trafficking, or even domestic terrorism, repeatedly dissolves once investigative tools are applied. The Rainbow family's fluid, leaderless character confounded the federal bureaucracy, which was accustomed to organizations with hierarchy, structure, and identifiable decision-makers. Because the family provided neither fixed targets nor centralized intent, agencies searched for anchors in rumor, confidential informants, and isolated criminal behavior. Each time, the result was the same. The allegations collapsed when checked against evidence, and the government's own files eventually recorded the absence of any substantiated collective wrongdoing. The administrative distance between suspicion and reality is clearest in the FBI's internal commentary. Field offices routinely framed early leads in dramatic terms: possible fugitives, cult practices, terrorist plots, drug conspiracies, yet the later memoranda almost always acknowledged that no such threat could be verified. Polygraphs failed, informants contradicted themselves, leads could not be located, and dates associated with predicted attacks or criminal operations passed without incident. Even in the 1990s drug trafficking narrative, where federal agencies invested the most energy, the flagship prosecution that was supposed to confirm a rainbow-linked network collapsed on evidentiary grounds, leaving the overarching theory unsupported. By the early 2000s, the Rainbow family appeared in federal workflows less as a suspected extremist group and more as a recurring special event requiring resource coordination with the Forest Service, state police, and local governments. The designation persisted, but it no longer rested on claims of subversion or terrorism. It reflected crowd size, environmental impact, and the bureaucratic habit of categorizing anything involving tens of thousands of itinerant participants under a national security rubric. Over time, the government's posture shifted from investigatory urgency to an uneasy managerial stance. The Rainbow family was not treated as benign. Drug use, sanitation, and occasional disorderly behavior remain points of friction, but the files show a gradual institutional acceptance that the gatherings were not organized threats requiring large-scale federal intervention. Instead, the principal challenges were logistical and legal: public land management, permit disputes, environmental protection, and the predictable presence of a small number of runaways, fugitives, or opportunistic offenders within a very large transient population. When courts intervened, they tended to restrict government actions rather than expand them, reinforcing constitutional limits on roadblocks, blanket searches, and forced permit compliance. By 2004, FBI case closures noted that gatherings had produced no information of investigative interest, a concise acknowledgement that the counterterrorism framing had outlasted its factual basis. Across the period, the meta-narrative is one of institutional expectation meeting empirical thinness. Government agencies repeatedly imagined the Rainbow family as a vessel for threats that matched contemporary anxieties: 1970s subversion, 1980s cult fears, 1990s narco networks, post-1995 domestic terrorism, yet the investigations consistently revealed a decentralized, disorganized, and largely apolitical countercultural phenomenon. The most durable conflicts were not about crime or extremism but about federal authority over public land and the administrative difficulty of regulating a mass gathering without formal leadership. The result is a portrait of a government frequently preparing for worst-case scenarios and just as frequently finding none, and a countercultural movement that elicited disproportionate attention not because of what it did, but because its structure, scale, and refusal to formalize made it incompatible with the methods and assumptions of modern federal law enforcement.